Hello, everyone. My name is Jennifer Hochul. I'm a partner in Husch Blackwell's intellectual property practice. Before we get started, I've been asked to take care of a couple of housekeeping items. At the bottom of your audio console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We'll try to answer all questions during the webcast today. But if a further answer is needed or we run out of time, we will answer those questions by email. A PDF of the presentation is available in the program materials folder. The program has been approved for legal education hours. So to report your hours, you click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for you to watch or share. And towards the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your needs. This is all for the housekeeping items, so we're going to go ahead and get started with our program, and I'm going to turn it over to my partner, Matt Camps.
Well, hi, everybody. Wonderful to be here with you today in a virtual setting. And I think appropriately, Jen and I are both beaming in from different locations. I'm at my home. She's in the office in a studio. And this is just kind of the way we practice now. But a brief introduction to me before I turn it over to Jen to introduce herself. I'm a partner at Husch Blackwell Chicago office. I am in our healthcare, life sciences, and education industry group with a focus on IP litigation and patent litigation. And like Jen, I think I'm uniquely qualified to talk about some of these issues because I joined Husch about 2 months before the pandemic started, and the virtual environment has just been a very pervasive thing that has affected advocacy and the way that we do things. I'm going to turn it over to Jen to briefly introduce herself before we get into an agenda and kind of talk about what we're going to map out for you today.
So as I said, my name is Jen Hochul, and I too started a couple months right before COVID. So I spent the first 3 months of my Husch career on the road, taking depositions in bi-coastal and in the middle and everywhere in between, and then packed up all my bags, put them away, and sat around for a month or two, not knowing what we were going to be doing, and then started taking remote depositions pretty early on. And there's been a lot of challenges to that, a lot of opportunities to that. And then Matt and I had the opportunity to try a case together last fall that was entirely remote. So we're going to talk about our experiences with that as well, and why we both think that some of what we've learned is obviously here to stay, and we're not going to probably ever be going back to that fully live world. So I will turn it back over to Matt.
So we have a brief agenda slide here kind of outlining what we're going to talk about today. Jen is going to walk you through some general considerations in the virtual advocacy environment. I'm going to tackle virtual depositions to the best of my ability, and then we're going to wrap up with virtual trials and hearings. As Jen said, we both have extensive experience with this. And to piggyback off of what she said, not only did I have a virtual trial with her that was a 5-day bench trial, prior to that I had an 8-day bench trial in 2021 in front of Judge Stark in the District of Delaware as part of a six-group joint defense group. We beamed into Delaware from Chicago, and these groups were scattered across the country. I've conducted remote depositions. I've defended them in person, defended them remotely. We've run the gamut here with the experience. So we're going to walk you through some of those real life experiences that we've had, but also talk about more general considerations that you might fold into your practice. So that's generally the outline that we're going to follow. I'm going to advance ahead here to a poll question. Now we've got 3 of these that you'll see during the course of the presentation. I'm going to give you some time to answer it, and I'll read through this first question here, which is, what is your industry that you are currently involved in? We have a few categories here. If you can select the one that most closely matches what you're doing so that we can kind of get a sense of what our audience is like, I'll give you a chance to answer now. And I'm sorry I didn't cue up the Jeopardy music for you guys. Okay, so we've had about 15 seconds there, and I'm going to advance the slide and we'll take a look at our results here. Got a nice mix here. Apologies and condolences to the food and agribusiness group, but we've got a good cross section of certain industry groups here. And I think that's the point, right? Is that irrespective of the industry that you're coming from, the virtual advocacy, as Jen said, is something that the horse is out of the barn. And judges in various jurisdictions are going to integrate this either heavily or lightly into their practice, but we're not really going to go back in certain ways. So it's going to be very interesting to walk through some of these things. I'm going to turn it back over to Jen, and she's going to walk through some general considerations before we dive into the more content-specific items.
Thanks, Matt. So we're going to talk about sort of 5 areas of general considerations. And the first one is probably the most easy to overlook, which is know the rules. Video considerations, I think we'll talk about, but people have been living in this virtual world now for 2 years, so lots of these are going to be familiar. Same with audio considerations. We'll talk about how to help other participants, and we'll talk about the importance of backup plans. With respect to knowing the rules, so this is one that I think caught some of us older practitioners by surprise, which is that some courts already had rules when we went to fully remote. Some courts had to draft the rules on the fly. Some courts have revised the rules as we're going. But most courts have some sort of standing rules or orders governing the use of remote technologies and how it is that they want us all to go about using them. A lot of it is technology dependent, but really spend some time with the court's rules, the judge's rules, talk to the clerk, see if there's a tech consultant that works for the court that you should be talking to, and really spend some time with those. We have cases where the judges govern even your username, and the username is really directed by the kind of proceeding that you are attending. And it will have a very special shorthand. What kind of party are you representing? Are you a party to the protective order? Which party are you representing? What's your name? Which seems to be the least important sometimes of the screen name. But I have one court where I practice that has this very specific structure that I have to use, and it can take me 10 minutes to get the technology to accept that name and get it up and running. So make sure that you check all of those kinds of rules. Are there rules about whether the video is supposed to be off or on when you're not speaking? Some courts will want everyone's video on all the time so they can watch and see sort of what everyone's doing. Some courts, because of bandwidth considerations, will say that anyone who isn't speaking should not be on video. So it's important to know what those rules are so that you can follow the decorum of the court. It's important to know things like, are there rules about where the witnesses can be or not be with relation to you? Can they be in the same room? Must they be in a separate room? And so it's important, again, to sort of take a good look at those rules. We've all seen the filter video. Look at your video before you get started. Spend some time thinking about the lighting. I'm in a studio that we built after COVID started. We have 3 of these now in the St. Louis office. We have them in every office. I have a blue screen behind me. I can have a green screen behind me. I can choose my backgrounds for the various proceedings that I'm in. And some of the proceedings, actually, the courts will tell you, I want a blurred background, or I don't want a blurred background because if you move, you disappear into the blurring. I have a really nice overhead light here in this studio. In my home office, I have a ring light that I use because my office has a lot of natural light, but when it's cloudy outside, I don't have any natural light in that office, so I have a ring light. Check your camera angles. We've all seen the Zoom camera angles where it's coming up from below and it looks terrible, or it's coming down from down from above. Check all of those things. Attire is something that's important and has been important for years since we've been videotaping depositions, which is to have something that is professional, that is not overly patterned, and that isn't going to jump around on screen. If you have certain patterns, it jumps around and gets very distracting for the court. The other thing that we've heard from lots of judges is please dress all the way to the bottom. At some point, you're going to stand up and walk away. You're going to, the camera's going to jostle, whatever it is. And if you're wearing running shorts instead of professional pants, or you're barefoot, those are things that can cause a lack of credibility at the very least. So make sure that you take care of all of those issues as if you are going to be live. And one of the things I think you'll hear from Matt and I throughout this presentation is, most of the same considerations will that you would have if you were live. So just have that same professional demeanor, have that same professional appearance. Audio. I have one judge who really insists that everyone use a headset, and it upsets him when we don't. But then you need to think about what kind of headset. After a hearing where the judge repeated that he wanted everybody to wear a headset, I ordered a headset and I put it on, and my children started laughing at me, telling me that I looked like I was about ready to land an airplane. It had the big over the ear, and it had a big microphone, and it looked absolutely ridiculous. People wear earbuds, they look like they're going skateboarding. So you have to kind of give some thought to what type of headset, if required, will look professional. Do you need a separate microphone? Again, in this room, we have a boom mic, which is great. It has great sound and it's not visible. So it's very seamless. I have other clients and experts who use a boom mic, but it's mounted, and they look like a radio announcer, right? Because it's in front of them, which is fine as long as you get good sound. The main thing I think is to really spend a lot of time on the sound, because as everyone on this call who is lawyers knows, the written record is the most important part of really any proceeding, and the sound is the only way we get that. And court reporters are particularly, it's been particularly challenging for court reporters because it's a little harder to hear sometimes. It's harder to see people's mouths. I mean, I don't know how many of you have court reporters who seem to lip read as well as they hear, and it's very difficult for them to be able to see as well through the video feed sometimes. And so speaking very slowly, which Matt and I are both capable of violating, speaking slowly and making sure that you give that pause so that the court reporter or the judge can jump in with questions or concerns are all very important considerations. The other considerations generally are other participants. What other participants are you in charge of, and are they going to be able to satisfy all the same video requirements, internet capacity requirements, audio requirements, being in a professional environment, what is the background, all of those things are things that you need to take into consideration. I've had a number of video depositions that have had to be rescheduled in the middle or on the fly because of internet problems. It's less of an issue in depositions. It's a much bigger problem in trials that we'll talk about, but it is something that you need to consider. Are there alternate modes of communication? Can they tether in through their phone? Do they have a backup location they can go to? If the audio goes out, can they move to a different place? So these are all things that you need to not only obviously be worried about for yourself, but also for the other participants. And to that extent, consider backup plans. Do you have an alternate internet connection, alternate camera? Alternate counsel is something that we do a lot, which is to say that making sure that maybe you have two lawyers on the line who can back each other up in case someone's technology goes down. The other person can step in and is capable of either conducting the deposition for an hour. I know Matt got a call one morning where he had to hop on a deposition because co-counsel's internet had gone down, and Matt had to come in and defend a deposition for an hour or two until that person's internet could get back up and running. Those are all things to take into account. And then I don't think any of us can stress enough the importance of having a tech professional throughout the process, both at the beginning to get you set up, throughout the day to troubleshoot, and also to help the other people that you're in charge of be able to get on the phone with them and help them get through the technology or the exhibit issues or whatever other issues they're having. So we rely heavily on our tech professionals to make this all run as smoothly as possible. So the main lesson from all of this is practice, practice, practice. We do practices with witnesses, we do practices with co-counsel, we do practices with anybody that we can get our hands on and that will practice with us to make sure that you are ready for contingencies, that you understand the technology, that you understand the room you're in, the chair you're sitting in, the lighting that you have. And most courts will do practice sessions with their technology people before hearings. The court reporters will all do run-throughs and help you with all of the exhibits and the video technology and any other technology. So the main issue is practice, practice, practice. That brings us to our next poll question, which is how many people have participated in a virtual deposition? And so I will give everybody a couple of seconds to answer the question as to whether or not you've participated in a virtual deposition. And as many of you know, the poll questions are a CLE requirement in some states. So that's why we have these in here, not to test you too hard, but to make sure everybody's paying attention. So we've got some answers. So it looks like 43% of our respondents have, 52% have not, and 6% is not applicable to your practice. I think for the 52% of you that have not, you will. And Matt's going to talk about that.
All right, thanks, Jen. So virtual depositions, we have another little roadmap slide here. We'll talk about some general preparation considerations. Some of this might be a bit repetitive because Jen covered a lot of awesome ground earlier. And then we'll talk about taking, we'll talk about defending. Before I jump into that, in the virtual environment, just with the trial that Jen and I were on, I had the opportunity to take multiple depositions virtually, both for domestic and international witnesses. The international witnesses required translators. That created some interesting logistical issues. I also defended actually the same witness who was an expert in our case, both in person and remotely. And so it kind of has some interesting takeaways from that. This all led to a virtual trial, as Jen mentioned before. So I want to walk through just some general considerations and some strategic considerations, and also talk about the advantages and disadvantages of the virtual environment kind of being more pervasive with these proceedings. And then we'll move on from there. So let me advance to the next slide here. Talk about preparation here. So again, Jen covered most of this ground, but one of the biggest things going into these depositions is realizing that you have more time constraints than you would in an in-person environment. And what I mean by that is conferring with opposing counsel well in advance of the deposition after it gets noticed up and going over some ground rules that you can both agree on is extremely important. And you may not have the time that you normally would in an in-person deposition. I'll give you an example of that. When the pandemic first started, and this is becoming more old hat, we were sending boxes of exhibits both to opposing counsel and the witness. And think about the effort and labor that goes into having all of that stuff teed up and shipped well in advance of the deposition. Your prep time is something that is affected rather dramatically. So going over with opposing counsel, hey, are we going to use a virtual platform? Does everything need to be physical paper copies, or is it a hybrid of both? Negotiating that up front is going to relieve a lot of stress on the back end, and it's going to give the witness, whether you're taking or defending, a chance to know what they expect. A real world example of that is one of the experts that I defended multiple times in this ITC case Jen and I were on. We negotiated beforehand that she could have paper copies of her reports and certain exhibits that we knew were going to be used just to save time and to allow her to be able to flip through her report manually. And it might seem like a small thing, but it's something that you should really consider up front. Hey, what is this witness definitely going to be looking at? And is it possible that we can have a belt and suspenders approach so they're not stuck looking at their computer screen if it's a virtual platform? Again, practice, practice, practice. This is about your connectivity. It's about the witnesses. Especially if you're defending, you've got another person to kind of take care of and ensure that they're comfortable, especially if they're not in the same room with you. So ensuring that they have the internet horsepower to be able to deal with it, a multiple monitors set up to potentially be able to navigate exhibits and see what's on camera. Some of these witnesses don't have that set up. Maybe they don't have the appropriate background, or they've never been deposed. Going through all of these things and how they're going to appear on camera, how they're going to sound, and how they're going to present themselves, especially if something's being recorded, is something that you have to walk through in a practice environment, just to make sure there's not any issues on game day. And I kind of covered the connectivity and staging with that rambling answer there. So let's move on to the next slide and talk about taking. Okay, and we've got our little sword graphic here, so let's move on. And again, we talked about exhibits here. When you're taking, I think one of the biggest things that I learned is you now have the ability to potentially have somebody run the hot seat for you on a virtual platform and present the exhibits live. We've got a wonderful group of paralegals here at Husch who are adept at using these virtual platforms. And I think it's a huge consideration for you, because instead of you sliding that paper exhibit across the table, now you might have a professional that has kind of the flow of your deposition teed up on their screen so that you can stay focused on the questioning, which is something I'll cover in the next couple of slides, is a little bit more difficult to do in a virtual context. Again, are you using physical copies of the exhibits? Do you want the witness to have a copy of their expert report? Some of these things can really grease the wheels and make your life easy so that you're not flipping back and forth to things. So I would strongly consider, if you've got a primary set of exhibits, shipping those beforehand or talking with opposing counsel and saying, hey, your witness can have these. I don't care. We're going to mark them virtually. We're going to mark them, they can have a physical copy of that to be able to flip through. It'll help save you time and maintain flow. Where are you deposing the witness from? I'm in my home office right now. I strongly consider going into the office if you're taking, to make sure that you're availing yourself to your office amenities and ostensibly better internet and connectivity and technology, and having IT potentially on site to help you out if something goes wrong. Maybe you can be a little bit more flexible when you're defending. Real-time transcript. This is huge. As Jen said, at the end of the day, we're trying to create a record, an accurate record, especially if we're taking, that gives us nice, clean Q&As. Well, I can tell you that the amount of the ability to muddle a transcript is increased exponentially in a virtual environment. So having real-time transcript is a consideration to have available so that you can have that on one screen and you see that what is being transcribed and what you have asked is being accurately conveyed. The ability to be able to check yourself in real time is a huge benefit. So I would strongly recommend, if that's not been incorporated into your taking capabilities, that you do so that you have the script there. And this sounds like a lot's going to be going on, and it is, but we've learned to navigate multiple monitors and do this effectively. That's our friend Judge Dredd here. So how do we maintain control and flow during a virtual deposition that you are taking? One thing that I've noticed, reading body language is much more difficult. You have a cropped view of a witness potentially. From the waist up, you can't necessarily see them moving around in their chair, how they're necessarily reacting. You might have one angle on them that you wouldn't necessarily have in a conference room. So how do you combat that? Well, I think that the biggest thing is to get to the point, ask clear, concise questions, consult your real-time transcript, and make sure that you rein opposing counsel in early. Whether this is by stipulation beforehand on the form and type of objections that can be made, that could potentially be negotiated ahead of time, or that you're even more cognizant of shutting down speaking objections so that you can get clear answers from the witness. I think it's imperative that your questions are concise, clear, and to the point so that the transcript reflects that, and so that you can get into a flow a little bit better. That might require more prep on the front end. It might require more scripting from you and less deviation from the script. But I can say the control can be an issue. One of the other issues is that opposing counsel, especially if they are in the room with the witness and you are not physically present, can produce some issues. The ability to police opposing counsel, just like the ability to read body language, is somewhat nullified or dulled in a virtual setting. So again, setting expectations up front, this can be in the prep session or during the depositions, to really limit certain types of objections, to maintain ground rules, and to potentially involve the court if necessary, right, are all things that you have at your disposal. But I think the point is that if your witness is beaming in from a virtual location, they may have a different comfort level, a different kind of lax attitude about things, and opposing counsel may feel more emboldened to interrupt your flow. And the ability to rein that in and rein that in early is a consideration that you definitely have to have front of mind.
And Matt, I'm going to interrupt you for a second and say, have you had to do this, which I've had to do, which is to ask a witness, what are you looking at? Do you have notes? Can you hold up the piece of paper that you're looking at? And you have to take control in other ways that you normally in a live environment you would be able to see and not have to have that sort of uncomfortable moment where you're like, what are you looking at, sir?
Jen asked a great question. The answer is yes. I had an expert I was deposing where he was writing something down and kind of looking down at what looked like a napkin, and it ended up being a napkin and just totally non-controversial. But it is weird. You have a laundry list of questions during the taking portion of that you maybe didn't have because you can actually see the witness physically. Sir or ma'am, are you in the room alone? Who else is there with you? What do I hear in the background there? Why do you keep looking to the side? These are all things that you may have to incorporate into your vernacular to maintain control because you're just not there. And I'm not saying this to like induce a sense of paranoia, but the whole point is that you have a list of considerations that maybe you didn't have before. If you incorporate them into your initial set of questions right before you get into their background, have it. But I strongly suggest having those items scripted just to make sure that you level set. And also, if you do see peculiar behavior, point it out so that it's on the record. You know, I want to know for the record that the witness keeps looking to their left every time I'm asking them a question. I asked them what's over there. They said nothing, but this is happening. Make sure to point peculiar behavior out. Again, it's all about the transcript. And if the transcript reflects conduct that would not take place in person, but is taking place virtually, it has to be noted. So advantages and disadvantages, cost savings, this is an obvious one. And I'll give you a fun anecdote when we get to the defense section here. About how big those cost savings can be, but this is a big one, right? Do you have to fly to depose a tertiary fact witness in person at some location that involves hotel rooms, travel, the cost to existing clients, the cost to clients whose work you may have been doing, but for the fact that you're traveling? You go down the list, and the virtual environment definitely offers you an opportunity to triage especially fact witnesses that aren't testifying on behalf of any defendants or plaintiffs in a 30B6 capacity. Do I really need to be there? And I think that the whole virtual environment allows us maybe to depose witnesses we wouldn't have due to constraints on budget, or to say, hey, for these 5, I think we can do it virtually and we're not going to lose anything. You can take depositions on your home turf. I mean, how nice is it to potentially do it from your home office or your office in Chicago? It's nice. It adds a comfort level. If you need to go print something out, or if you need to grab a snack or whatever, you kind of know where things are. It's a small thing, but potentially something that enhances the experience for the taking attorney. Organization. I mean, we're used to working on computers, and then falling back into a habit where we just have physical exhibits and we're just questioning a witness and don't necessarily have our laptop pulled up. Some people may work more effectively if they've got their technology in front of them. And can get through things a little faster and stay organized. It's an advantage. Disadvantages, we talked about some of these. Policing witnesses and opposing counsel becomes a more difficult task, and the vigilance has to be heightened as a result. Technology issues, this goes without saying. Jen had a nice anecdote earlier about an experience that I had to deal with. It happens. The one thing I will say is that judges, opposing counsel, et cetera, are relatively forgiving of technology issues, but we're 2 years in the pandemic now. They are less forgiving than they used to be. They expect a level of technological literacy and diligence that I don't think that they expected 2 years ago. So going forward, I do think this is something that you're going to have to be cognizant of. Might not be as forgiving, and there may be consequences to that, whether it's taken away from deposition time down the road, if there's a stipulation on hours, or maybe even trial time. Who knows? Inability to establish flow. We talked about that, especially for multiple people on the monitors. If you've got multiple attorneys, translators, whatever, there can be massive amount of interruptions, and the transcript not being as clean as a result. I think we've witnessed this. Sometimes it's much muddier than you think that it is. That's why the real-time transcript aspect is so important to this. I really think that if it didn't come out the way you wanted to, use your 7 hours and ask again if you're not strapped for time. I'm going to segue now to the defending portion of this, and now I've got a nice shield for you. All right, so let's move on here. The witness checklist. Now we're going to get into a little bit of anecdotal stuff, if you'll bear with me. This is just, and this is a non-exhaustive checklist, but this is stuff that I really think has helped me as I have learned in a technologically heavy environment for advocacy, things that I've got to do and remember, especially for witnesses that are naive to the deposition process, just generally, forget the fact that you're throwing technology on top of it. Can they handle the platform? Do they have multiple monitors where an exhibit can be shown and they can see the questioning attorney? If it's not sufficient, figure out a way to get them to a place where it is sufficient, whether that's your office, whether that's, if you have an expert, maybe their university has better amenities, but you have to be able to tease that out well in advance so that you do not have problems on game day. Attire, Jen mentioned this, yes, we all have what some judges have termed as Zoom exhaustion, right? But that doesn't mean that the decorum that we are used to as professionals and our witnesses by extension needs to fall by the wayside. So just a quick primer on that, on what they need to wear and how they need to present themselves and how the camera is going to capture them. It might be very different than they present in person. Demeanor, again, looking around, having things that might call into question the integrity of their testimony, all things that you should point out and just say, hey, I like this angle of you. Make sure you talk into the camera. Try not to fidget too much. I notice you're moving your chair. Just, stay locked in. Again, something you need to work through during practice. Background lighting, good chair, small things, but they might be sitting there for a while. Location that they're coming in from, camera angle, microphone position. Again, clean transcript, the ability to get through this thing as painlessly as possible, all considerations to go through. Distractions is an interesting one, right? Because some people have pets. Some people are getting deposed from their homes. Some people have kids. Life happens. And in a virtual environment, I think the bleeding between our personal lives and work, those lines have been blurred pretty extensively. And in some cases, it might be a cute and endearing thing, not during a deposition. So if they've got a small pet who barks a lot or chirps or whatever noise your pet makes, make sure that they're not a distraction. Because you don't want your witness thinking about anything but the question in front of them and how to answer that as succinctly as possible. And then physical copies of exhibits. I keep hammering this point, but it can really make the witness feel more comfortable if they don't feel like they're being blindsided by what's coming up on the screen. So if you got an expert, I would really, really push hard for them to have a copy of the report and certain exhibits in front of them. So other considerations for you as the attorney. Are you with the witness? I had the same expert witness where I defended her both remotely and in person. I think a lot of it's reading the personality of the witness. If you feel like they can handle the virtual environment and do it well and not fold, then fine. Have them come in from where they are most comfortable physically so that they can kind of survive the day. That said, if you've got a witness who really could use the support of having the attorney in the room and your rules allow for that, this same witness performed, I think, much better when I was there in person, maybe to the chagrin of the opposing counsel. And again, there were no shenanigans here, but I was physically there and there was a comfort level there of having somebody in your corner. So tease that out. Again, if you're defending the quaternary fact witness, maybe not. If it's your expert and case dispositive issues hang in the balance, yeah, probably be there if you can. Backup plans, Jen talked about this, have them. Know what you need to do. Do you need to dial in and maybe you're not taking this by video anymore? Figure that out. What happens if the witness is rattled in a virtual environment? Most of our virtual platforms now have breakout rooms such that we can, kind of disengage ourselves from the deposition for our 10 to 15 minute breaks. But I will say it becomes much more difficult to calm a witness that is upset in those breakout rooms. So again, maybe a consideration. Again, if your witness, you feel like that they can get easily rattled, being there in person and being able to say, hey, it's okay, you're doing great. We're going to get back in there. We've got only X amount of hours to go. Again, a consideration there. But breakout rooms are going to be one way that you can maybe talk to them, but know that it'll be an impersonal kind of dialogue, just, kind of like we're beaming into you a little bit. And then stipulations. Again, this goes to physical copies of exhibits, maybe the form and type of objections that you can make as defending counsel. All of these things are potentially things that we negotiated ahead of time. Think about that because dealing with issues during virtual depositions is a huge pain. So the more that you can clean up beforehand, the better things will go. And we've got our advantages and disadvantages. Again, unsurprisingly, there's some overlap here with taking depositions. I want to give you an anecdote that can kind of exemplify here how cost savings can work. One of the first depositions that I ever defended was what I would describe as an inconsequential fact witness who happened to be located in Huntsville, Alabama. I live in Chicago. So I flew down and defended Jerry. That was a direct flight, required me staying in Alabama for a couple of nights because I had a day of prep with him. We had the deposition. Opposing counsel could have taken 2 hours. They took 7. And on my flight home, I realized, it got canceled because a massive snowstorm hit Chicago. So I had to stay in Alabama an extra night. Flew out the next morning. All right, you get my direct flight to Huntsville. It's going to be great. The flight got diverted not once, not twice, but thrice. I was in 5 airports on one day: Columbia, Raleigh, LaGuardia, and then finally to Chicago, including the Huntsville airport. That's 5, O'Hare being the 5th, right? And, this whole planes, trains, and automobiles experience, I think, really exemplifies some of the strategizing that you can do as a litigator. Do I need to be there? And what is the cost savings, both monetarily and from a time and sanity standpoint? If I happen to do this virtually, I could bill my whatever it is, and then I can move on to my next client or be with my family or whatever, right? These are huge considerations to have as you're mapping out your litigation strategy, because you're going to have witnesses that fall into a certain hierarchy. Figure out where they fall and where you need to be or why you need to be there. And again, some of these advantages we covered before. The home turf aspect of this, we covered. I mean, being able to defend a deposition from your home office is sweet. It's nice. The witness might actually perform better in a virtual environment. If they're in their home and maybe they've got a non-yappy dog who's like slinked around their feet or whatever, that might give them a comfort level that they would not have in a conference room where all of a sudden it's like, the lights are on and it's real. They may perform better. Again, know your witness, know their personality, and know their importance on kind of the totem pole there, and figure out what works best for them and for you. Disadvantages: if you're separate from the witness, and I've experienced this firsthand, being able to calm and reassure them, very, very difficult to do in a virtual environment, especially if the train kind of comes off the track a little bit. It's a reality of it. So that is part of the cost benefit analysis here. The witness might actually feel less supported. They might not say it to you, but being next to you can offer a sense of comfort that being virtual cannot. Again, technology issues, they're kind of ubiquitous here. When defending, again, this is where having the backup attorney is huge. And it saved us on certain occasions. And objections can be more difficult to lodge. Again, this has to do with kind of the muddying of the transcript, but things are just more difficult. So again, the amount you have to be locked in and engaged, I'd say virtually, it's a bit different, and you just need to be, again, extra vigilant about when to lodge things. If there's any kind of latency in the internet, you might not be able to get your objection in time. So that's where the prep becomes very important. Your witness needs to understand, hey, they're going to ask your question. Please take a beat, allow me to object, and then we can move on. That concludes my portion of this. I'm going to flip it back over to Jen. She's going to talk about hearings and trials.
Actually, Matt, you're still up for a couple more. You're still up for a couple more. Oh,
okay. Never mind. You guys get more of me. This is great. Okay, so I'm going to talk about hearings. My apologies, Jen. So hearings, Jen covered this. This is the biggest thing in complaints that I've seen in judges, whether you're watching a YouTube video or they're writing an article about it. Holy crap, the witness or the attorney does not understand that this is my courtroom, okay? So again, you're in the courtroom, suit up, act like it. And if you have a witness or a client that needs to be in the courtroom, make sure that they are appropriately dressed as well. Attire, demeanor, and where you're connecting from. We're going to go through a couple of video examples here. These are issues, okay? And they may seem kind of comical, but they're funny until you get a witness that does this, okay? So again, remember where you are, remember what you're doing, and remember that having the Teams call with the litigation team in an informal setting is not what you should be carrying into the courtroom. Check your filters. Let's play a video. If it will play. There we go. The volume here. I don't have audio for you guys. I apologize. Okay. I was told it should be coming through for the audience. You know what, my friends? I apologize. I'm actually going to skip this video. This video was supposed to be taken out. You can watch it at your own leisure, but it's actually kind of a long one where a bunch of judges actually weigh in on do's and don'ts in a virtual setting, but it's about 4 minutes long. So I would recommend that you check our resources page at the end of this. If you want to watch it, it's actually really cool. They've got federal and state judges that kind of talk about some of the things we've talked about, but it's very interesting to hear from the horse's mouth. The video was supposed to be that fun cat filter video, which you've all seen, but I will paraphrase it for you. But basically, this attorney gets on and he's a cat, and it's hilarious. And he goes, "Well, Your Honor, I'm not a cat." And the judge is like, "I know." The judge was really cool about it. That was the person who actually posted the video, because you're not supposed to be recording those sessions, at least in his courtroom, as an illustrative point that during the virtual environment, if you share a computer, make sure you check that stuff in advance, because you might be dealing with an embarrassing moment here. Again, judge was very forgiving about that, but the cat video went viral and very illustrative that these are things that you're going to have to just kind of police that maybe you didn't before. You might have a cat filter on and not even know it until you're talking to a judge. The check usernames video is linked in the resources. Due to some colorful language used in that, we have elected not to play it, but this was also pulled from YouTube. The judge in the top left corner here had somebody who entered through Zoom in the bottom right-hand corner there with a very colorful username, but F word 3000. The judge was irate, as you can imagine, and sent this guy to the, I guess, a waiting room before he could re-enter the proceedings. Again, usernames are a thing, especially in the Zoom settings. What I've seen for Zoom trials and being able to link up, you have the ability to identify who you are, and the judge may ask you to do that if you're on the plaintiff or defense side. Make sure that your username is professional and reflects who you are, so that the court reporter knows who's there. Connecting from a professional location, I am going to play this video because it's hilarious.
Hey, my guys, this is a female guard working in the tight spot for it.
All right, I'm gonna need you to park your car and get out the car, okay?
You having a bad day? Just say that.
I'm not having a bad day until you started talking while driving at the same time that you're suspended. Okay.
Yeah, so I hope the audio came in through to you. I was told that it did in our chat here. But if you caught the end of that, the witness was driving on a suspended license and decided to enter the courtroom while driving. So not necessarily a best practice there, but it does go to say where you're connecting from, what's in your background, what distractions are potentially in the background, all important things that can disrupt a number of things. They can impact your credibility. They can disrupt your flow if you need it. Really, it happens. So I'm going to pause this video. Okay, good. All right, and now we are on to our poll question here. And Jen, I think I'm going to flip it back to you to take the poll and then take it to the finish line here. Is that what I'm doing?
Sure. So our last poll question is, do you plan to incorporate virtual advocacy into your practice or business going forward? And while we're waiting for the answers to that, I think, we all have the horror stories that Matt had of trying to get home from depositions that could have taken, the whole, this could have been an email, right? When I was a very young lawyer, had to fly to Detroit on December 23rd to take a deposition, and there was a snowstorm coming. And I figured out really quickly when I got to the airport why the senior partner had sent me to take that particular deposition, because the snowstorm hit and I barely made it home for Christmas. So I think there are lots and lots of opportunities to incorporate virtual advocacy. It's not a panacea. We're not going to use it for everything, but there are places for it. So looks like about 60% of you all plan to incorporate virtual advocacy, 15% won't, and 30% is not applicable. So I'm going to talk for a few minutes about virtual trials and hearings, kind of follow up on some of what Matt said, and focus more on the trial aspect of things. So the first thing I would say is it's incredibly important to understand the court's setup. So for video depositions, It's a little less important to understand what everybody else is doing because you're kind of just worried about you and the record. For the trial, it's really important to understand how the court's setup is. How many screens does the judge have? How are those screens configured? How many participants can the judge see? Do they want paper copies? All of these things are going to impact your presentation on a fundamental ground level. If the court has one screen and they can really only see maybe the witness or the presenting attorney, that's going to be a very different approach than the judge has two screens and it's split screen and they can see, an electronic exhibit. They can see the witness, they can see the taking attorney, the defending attorney. Those are very different setups. How many participant videos can the judge see? How are you going to object when it's your turn to do the objecting and not the questioning? I've had depositions, for example, where I've had to, sort of do this to the screen to get everyone to pay attention to me. How is the judge going to want you to interject to get those objections heard because of the limitations of the sound technology and the fact that, if you've got a witness who's speaking and they just keep speaking, technologically, your objection may not be able to be heard. How are you going to handle those things? Does the judge want to see you when you're not speaking? Or again, as I talked about before, or are you supposed to go off video? It's interesting. One thing that the courts have really told us is that in many ways, this is actually better for the judge. While they don't have the body language and some of those issues that they can see when they're in a live trial, at the same time, there are a couple of advantages to the court, one of which is they're getting a really good front-on shot of the witness. They can really see the witness clearly. There aren't the other courtroom distractions. There aren't people coming and going from the back of the courtroom. They're not worried about, what the bailiff is concerned about. Someone is, maybe being too loud in the back, whatever it is. They're really able to focus on the trial and the questioning and the witnesses. And so that is one of the advantages. The disadvantages are things like it's harder for, exhibits take a little bit longer. Who's controlling the judge's exhibits? Is the judge controlling their own exhibits? Is there a clerk who's feeding the exhibit? Are you using a trial technology where you're feeding the exhibits? So you have to make sure that you understand how all of those are going to impact the way that you try your case. We're going to show some pictures of the trial that Matt and I conducted to show what the room setup looked like. But room setup is a huge issue. Are you going to be in the same room as the witness, or are you going to have the witness down the hall? Are you going to be sitting or standing? The witness is generally going to be sitting. I've heard a lot. There's been a lot of debate about the sitting or standing. I tried it sitting in our trial, and I've been a lawyer for 27 years, something like that. I've never tried a case sitting down. I couldn't do it. I had to stand up. I, in fact, tried to do it standing up in flats. I've never tried a case in flats. I wear heels to court. I had to put my heels back on. You have to put that armor on, that demeanor on, whatever it is that you do in trial in a courtroom, you need to be doing in your virtual trial. Like I said, you need to be dressed. You need to be standing if that's what you're used to doing. Some lawyers will tell you that sitting is better for stability of the camera purposes, or it's a long day, whatever it is. I think you just have to, whatever it is that you do to bring that courtroom demeanor, you need to bring to the virtual trial. With the witness setup, Matt talked about the differences in defending a witness, both live, same witness, both live and remotely. I happened to put that witness on at trial, and I think she really benefited by being in the same room as the questioning attorney. Just that sort of physical support of being in the same room, I think really helped her. But now you're in the same room, you're on separate video, you have to be on separate video. What are you going to do about the sound system? Do you do a central microphone and hope that everyone gets picked up? We did lapel mics, which I think worked really well. So you have to think about those things. support staff, how are they going to help you? How is someone going to get you a note when you've missed an exhibit, or opposing counsel has interjected an exhibit that isn't of record or whatever? How are you going to handle, are you going to get text messages over your computer? You need to take into those things into account. You have some more advantages. You don't have the somebody having to come up and tap you on the shoulder and hand you a Post-it note like in trial, but you have to figure out how are you going to handle that. So here is the way we set up our room for the trial that we did. It was a remote trial insofar as opposing counsel and the court were remote. We elected to all be in one place. I say that for the most part. Matt stayed in Chicago. A couple of people stayed where they were, but for the most part, we were all in the witnesses and the questioning attorneys. We were all in one location. This computer that you're seeing right now with really the 3 screens is our technology person who was also in the same room. To the left, you see the podium, which is where the questioning attorney stood. To the right was the witness. And then we had large screens around the room that you could see exhibits displayed on. So here you can see I'm standing here so that you have some perspective on the room. That's where the questioning attorney stood. I did wear a jacket to court. I don't know why this picture is of me in a sweater, but I did wear a jacket to court and heels and fully dressed up lawyer, grown-up lawyer. But that was our regular questioning podium. And so, and whatever lawyer was doing the questioning stood at that podium. And then where the big screen is across from me, the witness was right under that. And so you were looking directly at the witness, but I could see the exhibits behind the witnesses. And then this was our fancy high-tech witness seat. The camera angles and the computer were odd, so we had to stick a box underneath the computer. But this was the witness's view of the participants, and then the exhibits were shown on a big screen behind me. So we had about 3, I think, big televisions in the room for everyone to be able to see. And this room is only for people participating at the time. So the witness, the technician, and whatever lawyer was doing the questioning or objecting. One of the things that we'll talk about in advantages that I did not anticipate but really thought was wonderful was this was the room that was the viewing room, as we called it. So the witnesses who weren't on the stand were in this room. The lawyers who weren't taking witnesses were in this room. The clients were in this room. Everyone basically that was watching the trial was in this room. Because you're watching the trial and because you're not on video, the court would ask that this room be on video in the morning so she could see sort of who was there. And then when we had protective order issues, everyone that was not under the protective order would leave that room. We had another room that they could just go do work and whatever. We had a lawyer that sat in that room who would certify to the court, you know, Your Honor, everyone has left the room. And that is something to think about. How are you going to handle when the courtroom is closed? Because there is no judge there in the courtroom to say, I know these 3 people need to leave. It's a little bit on Your Honor. And what she would do is she would have a counsel for whichever clients needed to leave to say, everyone who's not under the protective order, Your Honor, I certify has left the room. When everyone was in the room, though, what it allowed for that I thought was a really interesting benefit was real-time collaboration. So, for example, when the other side's expert was being questioned, I was in the room, for example, with our expert and our client. And because we weren't in a courtroom setting, we could have a real-time dialogue about what the expert was saying, how to counter what the expert was saying, what kinds of things we would want to, you know, cross-examine on, those kinds of things. And it was actually a really helpful real-time feedback, as opposed to in a live courtroom where everybody would be sort of scrambling down notes, and maybe you could read your notes and maybe, you know, you talk on a break about what you thought and things you could respond to, but you have a much more limited time to be able to do that. In this case, we were actually able to do that real time. So again, with respect to the witnesses, you need to, again, talk about these exact same things that Matt and I have been talking about, you know, location, technology management, exhibit handling. Demonstratives are a real challenge, as Matt showed you with the video that may or may not have worked with sound. Getting a demonstrative to work live virtually can be a challenge. And so really trying to figure out how are you going to amend your presentation from how you would do it if you were all in one room, where maybe the witness would stand up, walk across the room, go to the whiteboard things out. How are you going to do those things in a virtual trial is a bit of a different challenge. And then again, these agreements with respect to protocols, I alluded to the one about the protective order. How are you going to manage things like the protective order? How is the court, because what we've found in most of these hearings is that it's still a public proceeding, and the court wants there to be a live component to the public where they can watch it on, YouTube or on Zoom or however it is. How are you going to handle closing the courtroom when you're on confidential materials, those sorts of things? So having all of those agreements up front with respect to those protocols is really important. Again, lots of advantages, numerous forms of cost savings and time efficiencies. One of the time efficiencies that I found that was interesting is, in a normal trial with a jury or a judge, you spend a lot of time, who's going to be in the room? Who's going to stay in the court the entire time? Who is going to, be focused on the testimony the entire time? And you might have a lot of attorneys or staff sitting in the room kind of just in case. Whereas in a virtual trial, they're sitting in a different room just in case, but they're doing other things. Can't really do other things when you're sitting in a courtroom, right? That the judge frowns upon that. So, so there were a lot of time efficiencies where people were able to do things during trial days, when normally during trial days, you're all sitting at the table. That allowed for more participation by sort of what I would call non-lead counsel. We could have other lawyers who were doing other things kind of during the day, but they could still be there to argue motions without detracting from the presentation when they weren't sitting in the courtroom. I talked about that real-time client expert feedback and also the judge focus. They said that was really something that was interesting to the judges that have been polled about this, that you really can you focus on your screen and you focus on the witness and the exhibits, and you're not worried about all that stuff that's going on in your courtroom on a normal court day. The disadvantages are it does dampen personality. You have a harder time when you don't have that feedback loop to really develop those rapport sometimes with the court staff, with the court reporter. I miss the court reporters, right? I mean, you would travel with court reporters and be in rooms with them all day long, and now they show up at the very beginning on screen and then they're there the whole day, but you never really get that time to get that rapport. Lack of situational awareness is a problem when especially if your technology isn't set up right, you're really focusing on one part of the screen maybe, and you're not focused on, other parts. We had in the trial, sometimes the lawyers would get so focused on the witness, they would stop, they wouldn't look to their left on the screen to see that the judge was, sort of saying, hey, I've got questions, you need to stop talking, or, we need to take a break, or, we've all lost internet and you and I are the only ones left. It's harder to kind of have that situational awareness. You do have those technology issues that we talked about. And if you're all truly virtual, you don't have a war room. As Matt said, you might be on those Zoom calls afterwards, but it's a little harder to kind of have that collaboration. So I think I really liked the way we did it, which was to be virtual with respect to the other side in the court. But as a team, we were more together. I think that was, in my ideal sort of virtual trial, that would be the way you would do it. But I think there are certainly lots of advantages and disadvantages to doing these virtually. And I think, I think they're here to stay. It's going to be interesting to see how many courts pick this up for actual jury trials. Some are saying they actually think it broadens the amount of jurors, because you don't have to worry about transportation issues and things like that, and distance. I know our courthouse here in St. Louis, our federal courthouse, draws from 100 miles around. Certainly would be a lot easier for those people that live 90 miles away to participate by video. So it's going to be, I think, an interesting next few years as we hopefully come out of pandemic time to see how much of this and in what forums we are dealing with this for the future. So thank you all for your attendance, and on behalf of Matt and I, we appreciate your time, and everybody have a great Tuesday. I'm sure there's something I'm supposed to read at the end here that I'm going to look up right now. So To report your hours, click on the CEU icon at the bottom, and you will get a certificate of attendance tomorrow in the email. And please complete the survey, and we appreciate your attendance today. Thank you.